All rise. You may be seated.
Madam Clerk, if you'll please call the next final case for the day, please.
S24A0448, Jennifer Rosenbaum versus the state, Ashley Merchant for appellant, Samuel D'Entremont for appellee.
Good morning, Counsel. Ms. Merchant, you may proceed when you're ready.
Good morning. Thank you so much. May it please the court. Ashley Merchant on behalf of my co-counsel, Brian Steele, who wishes very much he could be here today, and representing Jennifer Rosenbaum. I want to start with what the state argued back in 2017. On June 23rd, 2017, the state said, if Corinne Mull continues to represent both defendants in this case, Jennifer and Joseph, there's no doubt that if they get convicted, there's going to be an ineffective assistance of counsel claim and argument made. There's no doubt, if you look at the entirety of just looking at the base facts, the type of charges, and the dual representation, that if this case, if there's a conviction and it goes up, whether there's a waiver or not, it will be reversed. And that's what we're here arguing today. This is exactly what happened. Ms. Mull was permitted in error to continue to represent both Joseph and Jennifer Rosenbaum. It resulted in an actual conflict, and it infected the entire trial. It infected her representation, and it infected the result. So I would ask, has anything changed the state's position besides the conviction in this case? And they actually addressed that Joseph's case is pending in the Court of Appeals. So that's not pending before this court because he was not convicted of murder like my client Jennifer was. Joseph was convicted of second degree, so his case is actually pending right now in the Court of Appeals. But the state addressed that question in their briefing in that case and said they attempted to answer it. They admitted the only thing that had changed was there was a trial and a conviction, and we now had Ms. Mull's testimony. But the thing about Ms. Mull's testimony at the motion for new trial is it actually supports our arguments here. It does the opposite of what the state argued. It strengthens what the state knew back in 2017 when they asked the trial court to disqualify Ms. Mull from representing both Jennifer and Joseph. The set of facts in this case demand separate counsel. This court, if there's ever a set of facts that demand separate counsel, it's a case like this. This court decided a case with similar, and I use the word similar in quotes, facts on a different issue, Bell versus State. And so I just want to draw the corollary to that. Imagine, and Justice Ellington, you wrote that opinion, imagine one lawyer representing Courtney Bell and Christopher McNabb in that case. No one could do that.
Isn't there pretty extensive evidence here about consultation with independent counsel and waiving?
No, Justice Warren, there's actually, the record does not actually have any proof that there was independent counsel other than myself, who was consulted in 2019. So that's important to note. So in 2017, the first indictment in this case was for malice murder. Both defendants were charged with felony murder and malice murder. Ms. Mull was then challenged for the conflict. Then the state re-indicted the case. So they charged Joseph with second degree with a criminal negligence theory. They charged Jennifer with malice, okay? So at that point, the conflict issue had already been litigated. The court said, Ms. Mull, you're still on. There was no additional waiver done at that point. So the waiver had already happened. So, and it's important to note, the waiver's not actually in the record here. So we don't even have a record we don't even have a waiver, an actual written waiver in this case. But we did have an
Is the waiver disputed?
Whether or not there is a waiver is not really disputed because we talked about it, and we actually had an expert that talked about it. But but we don't have it to look at here. But we do have some testimony, and so there was an expert called by the defense, Mr. Chandler, and he actually addressed your Honor's question. What he talked about was with the 2017 charge, the waiver was an issue. With the new charges, though, when Joseph was charged with criminal negligence for leaving Layla in Jennifer's care, it became an unwaiverable conflict. So at that point, what the law says is you can waive certain conflicts, but there's certain conflicts that a waiver doesn't matter. So even if we're not arguing that a waiver never happened. I mean, we're not blind to the fact.
Can you explain why that is unwaivable?
Yes, definitely. So, and I would just cite to Mr. Chandler's testimony. He explained that when you're charged with murder, the conflict could be waived under 1.7. But what he said was because Joseph is now charged with this second degree because he's charged with criminal negligence, it can't any longer be waived. And that's because it's the factual issues. It's an inherent conflict. It's a conflict because Joseph, the state's theory was Joseph should not have left Layla in Jennifer's care because he knew she was violent. That's the state's argument. And because he did that, and Jennifer ultimately, in the state's view, killed Layla, that's why he was criminally negligent. Because those are necessarily pitted against each other. Those claims are necessarily against, Jennifer and Joseph. They
Help me understand why they're necessarily pitted against one another if the theory of defense is absolute innocence.
Well, that's an interesting question because talking about the theory of defense, Ms. Mull actually used a theory of defense of accident. That was her theory.
I understand, but you say that they are necessarily, and
Right.
so the point I'm trying to get at is explain to me why they are necessarily, not what was here. If both defendants' theory of defense is absolute innocence, what the state has charged did not happen with respect to either of us, why would the charge itself create an absolute unwaivable conflict?
It's not necessarily the charge, the actual name of the charge, but what's charged in the indictment.
Yeah, I understand. Okay, the charges here.
Right.
Why, without respect to what happened in this case, because you're making the claim that it's unwaivable.
Right.
Why is it that the charges here, there's no set of facts under which a lawyer could represent both?
Because the liability that the state alleged for Joseph was that he was guilty for leaving, and you actually heard a case similar to that earlier today. He was guilty just by leaving the child with Layla. So his set of facts is I'm guilty because she's a bad person.
Why is that necessarily inconsistent with her accident defense?
Well, actually, the biggest reason that it's inconsistent is the medical examiner's testimony. So the medical examiner, the Henry County medical examiner, testified at trial that the fatal blow occurred an hour before the death actually occurred.
But that's saying the accident defense wasn't very good.
Besides not being very good, so there were a couple different options for defenses. There were different things that Ms. Mull could.
But if accident wasn't an unreasonable defense,
Right.
and that was the defense that was pursued, why is accident sort of necessarily incompatible with the defense of the other defendant?
Well, you can take Ms. Mull's testimony herself. She thought accident was a ridiculous defense. She thought that it was, her statement, and I have it somewhere, she specifically said that she thought it was ridiculous.
Because why? Ridiculous because?
Because of the evidence, because it didn't really fit with the evidence. Mostly the medical examiner's testimony, because the medical examiner testified that the fatal blow happened before the child was in Jennifer's care, and that likely what Jennifer saw that she thought was choking was actually a fatal seizure. So her saying that it was an accident.
Well, but saying that it wasn't well supported by the evidence
Right.
isn't enough to show that it was a ridiculous defense, because there are cases where there just isn't a good defense. And so you can have a bad defense still be the best one that's available.
Right. There was definitely much better defenses in this case, though. But to answer your question, it's Ms. Mull's testimony. She specifically said, and this was her quote, that this defense was outrageous and ridiculous, but that she had to put it up because it's what Jennifer told the police. But to answer your question, I think it's important to look at how you could have defended it without, and what the evidence actually supports as a good defense for Jennifer.
Are we still talking about the conflict, or are we moving over into justification?
No, we're just definitely talking about the conflict, and I did not plan on arguing much about the justification. I think that's a very discrete issue. I'm happy to talk about it.
But isn't the fact that Jennifer, in fact, did tell the police that it was an accident, I mean, that is a really relevant point that does, to some extent, kind of box you in. I mean, creative lawyers can get past lots of things.
It must inform your strategy.
It must inform your strategy, but let's just follow me down this path for a second. So Jennifer says it's an accident. The medical examiner testified it could have looked like an accident. It looked like a seizure. She thought the child was choking. So Jennifer has 2 children at this point. She is off with the older child. Layla is eating. She says she thinks Layla is choking. The medical examiner says this fatal seizure looked a lot like choking. There's no evidence that she was choking. There's no food in her mouth. There's nothing, medical. But Jennifer doesn't know that. All Jennifer knows is she's taking care of Millie. Layla looks like she's choking, potentially a fatal seizure. But Jennifer doesn't know that. Jennifer doesn't know what happened when Joseph was there. She has no idea. She has no idea what happened before she came home.
So are you saying that the theory of the defense should have been it wasn't even accident, it was just natural?
No, for Jennifer, not that it was natural. No, I think the theory, if I was defending it and I had to choose at this point, I think based on the medical examiner's testimony that Joseph was the one.
I guess I'm missing
Joseph.
how this links into the conflict point.
It links into the conflict point because it talks about how Miss Mull was actually conflicted.
You think the better argument was to point the finger at Joseph?
100%. You've got a child that you have concrete medical evidence suffered a non-accidental blow.
So when a couple of people who are close to each other don't want to point the finger at each other, don't they have the right to decide whether they want their defense to be one of not pointing the finger to at each other?
As long as they have separate counsel that is advising them of that, yes. But they did not. And so if they had two lawyers advising them, one lawyer sits down with Jennifer, one lawyer sits down with Joseph, goes over all the potential defenses, and they both decide independently with a lawyer that is not divided, a lawyer that is not conflicted, they decide we don't want to point the finger and this is the defense we want to do, then that's fine. But that's not what we have here.
Well, that's like the best case scenario, right? Often things don't work the way we want them to. Is there any other situation where it would have also been fine without like every, can they make that decision themselves? Knowing that there could be a conflict?
As long as they were fully apprised, the problem is they were not here. So,
Well, not only fully apprised, but fully apprised by separate lawyers.
right, fully apprised by separate lawyers. And this is not a big ask. This is what the Constitution requires. They require a conflict-free counsel. It's not like we're asking for 100 lawyers to come in.
Is your counsel across the way going to agree with the facts you set out about whether independent counsel was consulted, or is there a disagreement about that?
There's a disagreement, and I'm glad you brought that up because that was one of the things I wanted to make sure I had time to address. I believe that they do have a question about that, and so I just want to talk about that for a second. So the state believes that, and I'm not quite sure, I'll let them say exactly what they think, but whether or not there was consultation with independent counsel. What the facts show that there was I was the only person. So there's no extra lawyer anywhere. I'm the only other person that was consulted. And I was consulted in 2019. That's what the facts show. In May of 2019, I had an opinion that was relevant, and I was consulted about that case. That's all in the facts, so I'm not testifying in my place on that. The state argues extensively in their brief that there was another attorney somehow, independent counsel. But that's not what the evidence actually shows. The evidence actually shows, if you look at Ms. Mull's testimony and you look at what was actually admitted, she doesn't even think that there was someone else consulted.
So explain to me why actually consulting with independent counsel is absolutely necessary to avoid a conflict. My read of 1.7b is that they have to have the opportunity. But being offered the opportunity is very different from actually consulting.
As long as they're apprised. So yes, you could get there, but only if Ms. Mull had actually properly apprised them. And that has to happen on the record. There's a lot of different things that didn't happen in this case.
Does it have to happen on the record?
Well, there's a dissent opinion that says it should happen on the record. In this case, I would submit that it needs to happen on the record. Okay. It definitely, in my opinion, it should.
But there's not a legal authority you can cite that says it must happen on the record?
No,
okay.
there is not.
I agree it is always better for things that are important to happen on the record.
Right.
That doesn't make it reversible error for it not to.
Not that, but that's not really the crux of our issue, our argument, whether or not this issue was waived on the record. It's whether or not they were advised. And we don't have any evidence that they were advised of any of this information. All we have is Ms. Mull saying, I said there could be a potential conflict because the state brought it up. You guys can go look at another lawyer if you want. But what the evidence shows is as soon as they called me about a different issue, she said, I'm going to quit if you call another lawyer. So the only time that they actually
And
consulted.
that's disputed as well, correct? That characterization?
No, that's not. That's actually in the record. That is, let's see. The state put in one email and we put in one email, but that's actually in the record. her email is in the record, and I will tell you exactly where. It is at page 258 of the record, but it's an email where as soon as, this is in May 2019, as soon as she had reached out to my office about the appeal, Ms. Mole said, if you're going to hire someone else for the appeal, you need to hire someone else for the trial as well. I will not be second guessed. And then she was questioned extensively about that and said that's true. And her quote.
And why would that, why does that violate their rights?
It's a big issue because the trial happened in August of 2019. This is in May, so this is 2-3 months before. If you dare to talk to another lawyer about an issue, I quit. They didn't have any money because at that point they had already filed for indigency status.
Do trials ever get extended when counsel changes?
It did not in this case. It actually, in the record, they had asked for that, and it had been denied. There was a very contentious hearing, it's in the record, where the judge said, I am not continuing this another time. And he thought that this, they wanted to be able to save up more money, so what the record shows is they wanted to save up more money to get another expert. Dr. Sperry was their expert. Some things happened with him. He was not going to be a great trial witness anymore because he had some issues of his own. So they wanted a new expert, but they ran out of money. So they were stuck with Corinne Mole, and they were stuck with Dr. Sperry. They went to the court and said, we need money. Court said no. They said, well, we need a continuance then to get money to get a new expert. Court said, no, you're going to trial.
That's different than asking for a continuance because your counsel's changed. That's a separate issue.
Right. They had not asked because their counsel changed, but the court made very clear in that record, in that hearing, we are not continuing this case again. This train is moving forward.
Can I ask a different question? And it may be a bit unfair, and so if you're not able to answer it,
Okay.
that's okay. The Sixth Amendment guarantees a right of conflict-free counsel.
Yes.
Why is the conflict that is assessed under the Sixth Amendment determined by state rules of professional conduct?
Well, I think there's a constitutional argument as well. I mean, I think everything is the backbone of it is the Constitution, whether or not there's a constitutional right to have conflict-free counsel. We look at it through the lens of the rules of professional responsibility, but the reason I couldn't answer some of your questions earlier, absolute, is because it's a continuum. It's one of those things we know it when we see it sort of situation.
So the fact that a rule of professional conduct may say something is okay or not okay isn't the end of the question of is it a conflict for purposes of the Sixth Amendment?
100%. It's a very, and that's one of the reasons you haven't heard me cite much law, because this is a factual dispute. This is an issue where the facts are what matters. And I think that's why we don't have a bright line rule that says you can never represent two people at one time. We can't have that bright line rule. That doesn't make sense. It's not applicable in all cases. But in a case like this, it definitely is.
So what is that rule that you would like, you think that should control? How would we articulate that rule so that folks in the future aren't left with, we'll know it when we see it, when we show up?
Well, I think we already have it, Judge. I think we have that rule, and I just think it wasn't followed here. We've got the rule that says that if there's an actual conflict, does it affect the representation? Not does it affect the outcome, but does it affect the representation?
That's sort of presuming the outcome, because the whole question is what's the actual conflict? Like,
Right.
what is the rule to determine whether there's an actual conflict?
Right, whether there's an actual conflict. So in this case, we would argue that there is an actual conflict. But even if there wasn't an actual conflict, there's still enough evidence.
Right, okay,
of
but-
prejudice.
Is the presence of arguably antagonistic defenses enough to trigger this rule?
That's what the law says when there's an actual conflict. But what the law says is
But
it has
counsel,
to be something.
Counsel, I mean, you're answering what is an actual conflict by saying it's an actual conflict when there's an actual conflict. So we do need contours on how to define that, because it can't be that everything is just case by case. If you're looking for a real rule.
And I have
And that's my question, is whenever, you said that we can't have a rule that says you can't represent two or more defendants.
Mm-hmm.
But if what you've just answered me is right, that if there is an arguable way that they could have antagonistic defenses, then there's a conflict, then the rule is you can't ever, because any capable advocate could conceive of some way that you could have antagonistic defenses.
Well, but the law says it can't just be some fantastical way. You can't just come up with some non-palpable, and I think is the term.
So what is it that what is it?
What the rule says now is if it significantly affected counsel's performance. So what the rule is counsel's performance. Yes, it did here. Definitely did
The
here.
conflict, what's the evidence that the conflict that counsel observed affected the defense of either of the clients?
There's three things, and they're all based in case law. The actual conflict existed because trial counsel was held back from raising a potentially meritorious issue because of the conflict.
And what did she say? What was her testimony that she did not advance based on the conflict?
She did not advance the issue that Joseph did this. She testified about 10 different times about that.
Well, wasn't that based in part on the party's unified front defense?
Yes, because she supported that
So
defense.
you were judging this in hindsight that it was a better argument. And
Well-
that better argument would have then therefore created a conflict.
But that's why they are supposed to be informed of that. You know, a better argument, as long as if Jennifer and Joseph had been told, these are all the potential arguments, Jennifer, the Emmy puts the time of the fatal blow when you weren't there. It puts it when Joseph was there. And the Emmy supports that you probably had no idea, and your choking actually makes sense because it was a fatal seizure and it looked like choking. If Jennifer had been told all of that, I think she would have had a very different opinion. She was not apprised of all those things. And that's the problem. That's the problem here. You've got a conflict, and you've got a lawyer just saying, trust me, we don't have a conflict. Oh, sorry. Thank you.
Thank you, counsel.